Death by DNR. This is one of many stories of the state of Texas declaring war on the elderly. Governor Greg Abbott stated that when he was Attorney General that exploiting and abusing the elderly would not be tolerated in Texas. He forgot to include unless you are a certified guardianship service provider, a judge, or a probate attorney. And after many months of finding myself, Sherry Johnston, and my mother, Willie Jo Mills, tangled up in litigation concerning the exploitation of the elderly in Harris County, and Willie Jo Mills, being a ward under a forced guardianship, was forced to die at the hands of a state licensed guardianship service provider, Ginger Lott, with the stamp of approval by the judge of Harris County, Christine Butts. Willie Jo died at the hands of Harris County Judge Christine Butts, Associate Judge Corinna Comstock, Sherry Fox, the court coordinator, and the court-appointed Ed Lynham hired Rayner. Certified guardianship service provider Ginger Lott, Ginger's court-appointed attorney Louis Dida, and finally Jason Ostrom, Larry Mills' attorney. Willie Jo Mills was forced to pay for all the attorney fees from her estate, spending hundreds of thousands of dollars at over $1,150 an hour. And after filing 3 emergency restraining orders in Harris County against Ginger Lott and ignored by Harris County Probate Court 4 Judge Christine Butts, mother Willie Jo Mills died. After mother's death, I requested medical records from the court-appointed guardianship service provider Ginger Lott and attorney David Dexel. Both responded back, said that they did not have medical records on Willie Jo. I was able to get mom's medical records from the hospital and found out that mother was constantly given dangerous drugs that made her deathly sick while under Ginger's care. The record states that the caregiver falsely gave information and medical history to the hospitals when mother was being admitted into the emergency rooms. During Willie Jo's experience of Ginger Lott being her guardian, mother was moved to another facility across town to make it almost impossible for her family and friends to see her. The Ginger attorney makes it very intimidating remark that Willie Jo could pay them to come see her. After Willie Jo finally died, I filed a complaint with the Judicial Branch Certification Commission Board to try to get Ginger certification revoked. I sent the review board over 700 pages of documents, abusive pictures, videos, threatening emails against the family from Ginger, and audio recordings exposing the very bad behavior of Ginger and also her medically battering mom. The review board had their investigation and stated that Ginger did not breach or violate any standards. I asked the review board to give me a description of what minimum care was, and the review board could not give me any examples. So the minimum standards is anything that the board or commission wants it to be. Ginger refused to take Willie Jo to a specialist, even though she was in good shape before Ginger became her successor guardian. And before Ginger became successor guardian, Willie Jo Mills was eating hamburgers, sharing stories with her children, and then Ginger decided that the only nursing home doctors would treat Willie Jo and refused to take mother to a specialist. Ginger discontinued her physical therapy and only allowed a speech therapist to treat mother by singing to her and trying to get mom to talk to them. I stated that Ginger violated numerous standards, and at the end of the certification review board hearing, the review board committee told the guardianship certification commissioners that the reason mother did not receive any physical therapy for over a year and would not be allowed to see a cardiologist, a preliminary specialist, or an internalist is because back in 2006, When mother was at home, she signed a out of hospital do not resuscitate. And after all the evidence was in, the commissioners agreed to dismiss my complaint. The review board and the commissioners consist of probate judges and attorneys. The commission determined that in 2006, a out of hospital DNR, which simply means do not resuscitate, released Ginger of any wrongdoing of refusing to provide physical therapy and on a medical specialist for over a year. That alone gave them justification to dismiss my complaint. In conclusion, I believe that after testifying at the state capitol in Austin in 2015 against the bills being passed that protect the judges, the attorneys, and guardianship service providers, and the complaint process at the JBCC against certified guardianship service provider Ginger Lott, that the state of Texas today intentionally euthanizes their elderly citizens. I believe that evidence with Willie Joe Mills' complaint has shown that the state of Texas has partnered with local elected probate judges in Harris and other counties to authorize the probate courts to view your personal checking accounts in a state to see if you can afford a guardianship with House Bill 1438, sponsored by Representative Sophronia Thompson and the statutory probate judge Guy Herman at the 84th legislative session. The state and the probate attorneys have partnered with the probate judges to force our elderly into guardianships that the judge will award the certified guardianship service providers and attorneys the ability to drain their family of everything they ever saved by attorney fees, selling the estates for pennies on the dollar, and for assisted living facilities to exploit the ward, and doctors exploiting Medicare, and finally terminate the ward through hospice, thus getting the elderly off the Medicare expense. The system is broken and the elderly are forced on hospice with just a mere DNR. The complaint process was monitored by the Attorney General's oversight and agreed that it is not a crime in Texas to abuse, exploit, and neglect the elderly if you are a judge, a certified guardianship service provider, a court officer, doctor, or attorney. The state of Texas will not prosecute anyone that completes a 3-hour course furnished by the state of Texas for violations against the elderly. Please watch the last 15 minutes of the hearing February the 5th, 2016 at the Guardianship Commissioners affirming that the probate judges, commissioners' courts, nor the Attorney General's office will protect our elderly. The laws protect the animals from abuse, but the laws does nothing to protect the elderly from certified guardianship service providers, probate attorneys, and judges. Guardianship awarded to a certified guardianship service provider or attorney means that a person can be medically abused, exploited, neglected because there is no minimum standards. Thank you.
McLean, would you like to add anything? I mean, you've heard the comments of the...
Yes, Mr. Chairman, I think the only thing I will add is that it is our understanding that during the process of Mrs. Mills' failing health, that the DNR that had been put in place well before the guardianship that she had signed herself was being honored by Ms. Lott. And that would be the explanation for not providing physical therapy or other forms of care and treatment that Mrs. Johnston was insisting on doing. It's very hard to honor a DNR and watching her die, and we have a lot of sympathy for Ms. Johnston.
Right.
Mr. McLean, there were two issues specifically that I asked to be returned to you all for consideration this last round. Could you speak a little bit to the two issues that we asked you to look at specifically, and what your specific thoughts were related to that?
With regard to the issue of whether or not the standard was followed about consulting with family upon being appointed guardian to give proper medical history and information necessary to make decisions moving forward, it was very relevant to us that Ms. Lott had apparently served for quite some time as a case manager for Mrs. Mills, while the previous guardian was in charge. So it wasn't like she came into the situation brand new and fresh. She already had experience in case management and the decision-making process leading up to that. It's also our understanding that after she was appointed, she did continue to consult with physicians and healthcare providers and some family members.
And so this is the second issue. The second issue we sent back to you was about family member access.
Correct.
And what were your thoughts about that issue?
The recommendation of the committee was to recommend to the commission to find that there was no violation of that standard. My personal thoughts on that issue as we were discussing it is that, and of course the standard says that family visitation is important and should be encouraged when it's in the best interest of the whole. And so while we found a few examples of actual encouragement, what we focused more upon in our deliberations were the fact that visitation had to be suspended initially because apparently there was an incident where Mrs. Johnson was trying to apply breathing treatments to her mother that had not been approved, and also trying to, looks like she was trying to treat a sore that her mother had improperly and possibly interfering with the treatment already underway, whether it was an antibiotic ointment or something like that that was being scraped off the wound. And so because of that, her visitation was initially suspended. But, and I believe that was in September or October, the fall of 2013, I believe. And then it looks like just right around Christmas time, Ms. Lott took steps to remedy the situation. I believe it was a meeting between Ms. Lott, the nursing home, assisted living facility administration, and Mrs. Johnston to clarify what was going to be allowed, what was not going to be allowed. Visitation was in there.
It's my understanding from the materials that I've read that there were several children of the ward, or more than one. Is that right?
I believe so. I believe, I may be incorrect, but I believe there were 2 daughters and a son.
That's correct.
Pardon me. Yes.
And so the restriction on visitations, were those restrictions that were applied to everyone, or were they applied specifically?
My understanding was that it was only applied to Mrs. Johnston.
Okay. And so you feel on the 2 issues we've sent back to you, you feel as though Ms. Lott was not at fault on those 2 issues. Is that my understanding?
Yes, we don't believe that there was a clear violation of the minimum standards that apply to guardians.
Okay, so we've heard a couple people say today that at the last meeting of this commission that there was an opportunity afforded for your committee to look at additional issues. Was there anything that your committee believed required further review?
I don't believe so. During the committee meeting, it was our understanding that we would look primarily at those 2 issues, which we did, and we did not spend a great deal of time deliberating or re-examining other issues.
And the 700 pages of records that have been referred to several times, we talked about at the last meeting, do you believe that y'all reviewed those in sufficient depth prior to your last recommendation such that you felt comfortable with your recommendation?
Yes.
Thank you.
Thank you, sir. Ms. Johnson, you've already given a very significant statement, but I see that you would like to speak again. I will allow you to do so very briefly, okay?
Thank you, sir. To clarify some stuff that went on, in September, my visitation was revoked, and Ms. Lott did reinstate it in October, and she denied it again in, I think it was the end of October, because I went into the nursing home where she was at. Mother had a bowel movement that made a big mess everywhere. Nobody would clean her up. So I was cleaning her up, and I was taking the stuff off of her, and she had a bandage on her behind that had this stuff all over it, so it had to be taken off. party was the fact I took a picture of her bed sores. It wasn't the fact that I cleaned her up or I was trying to do anything crazy with her. They did not want me taking pictures of what they were doing. And the treatment I was giving mother was a breathing treatment. And yes, I was giving her breathing treatment, and they knew I did this, and there wasn't a problem with it. And I was putting saline in it. They knew I put saline in it. It would kind of cleanse your eyes out. They didn't have a problem with that. They turned this into Epsom salt, and I'm a criminal. And no, she did not initiate my reinstation. We had to file an emergency restraining order to get myself back in there, and for her, the judge, to address what she was doing to my mother, and instead of addressing this poor behavior she had and neglecting my mother, they sat there for 3 hours and we talked about the Jews. We didn't talk about the treatment of my mother. We talked about what kind of Jews I made my mother. So no, she did not initiate this. And I wanted to make that clear to the board that no, I didn't get my visitation revoked because of my poor behavior. I got it revoked most of the time and threatened on a daily basis. I would take pictures and I would take videos. That's why I had 700-some pages of evidence.
Okay, thank you, Ms. Johnson, very much. All
I
right,
have
Commission.
one question, Commissioner.
Ma'am, is it about this case or is it about guardianships in general?
Well, the only thing
No, ma'am, please answer my question. Is it about this case?
Yes.
Okay, what is your question?
My thing is it a conflict of interest when you have a board member that may be in that area?
No.
No. We have a court reporter on this commission, and we have someone in the guardianship industry on the commission. So no, it's we have people on the commission who are knowledgeable of these professions. So no, it's not a conflict of interest. Ma'am, you also have spoken very. You've had a significant comment to the commission, but I see you want to say something else. If I will allow you to speak, but it must be very brief. Okay.
Also, too, whenever Ginger Lott took over the case, which we submitted to them, the first thing we got from Ginger Lott was a letter stating, in regards to the medical records, that no medical records would be given to us. It would have to go through her. I spoke with the office, the review board. I told them it's actually in the list of stuff that was given to you. She said she was going to give us medical records, medical information concerning my grandmother. Within a few days, we received another letter saying that she seek legal counsel because she's no longer going to give us any more information, or any information, period. I just wanted to...
Thank you very much. All right, commission members, is there a motion?
Your Honor, I'm going to move to accept the recommendation of the board.
Is there a second?
I'll second that, although the concerns that have been raised, I think no one here would dispute that facilitating visitation between family members, regardless of who's the guardian, is something that all of us are interested in. And while others might have handled this differently, I will agree that it appears that this has been looked into fairly thoroughly, and I submit that maybe you all see it differently. But under the circumstances, I think it's probably appropriate to go ahead and accept the recommendation. Also, others might have done it differently, but it doesn't appear that it was anything improper.
We have a motion and a second. Discussion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Ladies, thank you very much for your comments today. We are moving forward now to item H, Court Reporter Certification Complaint Review Committee, January 12, in the matter of Karen Woolsey, CSR 15-018-28076. Ms. Mohan.
Thank you, Your Honor. Just a brief factual summary. I reviewed the facts and the response from the respondent show on September 30th, 2014, the complainant requested in writing a transcript and asked for the amount of the deposit. It was not until July 2nd, 2015 that the respondent replied and requested that the complainant complete a form and formally request a transcript. On June 11, 2015, the complainant asked for an update on the status of the transcripts. It wasn't until June 30th, 2015 that the respondent replied to that email. The unanimous
Is there a motion? Second? Is there a second? We have a motion and a second to follow the recommendation of the Complaint Review Committee. Discussion? All in favor say aye. All opposed say no. Motion carries. Ms. Mohan, looking at this agenda, looks like we have covered everything on the first page of the agenda, and that we're now down to Roman numeral 8, Advisory Board Complaint Review Committee recommendations for disciplinary action. Court Reporter Certification Complaint Review Committee. Item A, in the matter of Helen Wooten. Also item B, in the matter of Helen Wooten. CSR 15-05447, 052, and 053. You may proceed.
Thank you, Your Honor. With the Commission's permission, may I address Roman numeral 8A and B together?
Yes.
And I provided you with summaries of these cases. In the first case, the respondent violated the following. She failed to timely file records in numerous cases with the 10th Court of Appeals. And in order